We'll go ahead. I'm John Lee with St. Louis Real Estate Investors Association. Today is September the 25th, 2020. Moving right along, and we have our weekly updates with Davis Travaglini LLC, and we have Kathie Davis. She's going to fill us in. So, Kathie, are you with us here? You can unmute
I am.
yourself, please.
Yeah.
Okay.
And Christine is here with us today too, although she feels like she doesn't have much new to talk about. Chris is in a mediation, so he's not with us, but I guess I will lead with the big news that we just got 5 minutes ago. Our writ was denied by the Court of Appeals. We felt that this might happen because they're not customarily granted, and we don't get, all we had was our pleadings. We don't generally get oral arguments and that kind of thing in that. So we're ready to file it with the Missouri Supreme Court, and we'll be doing that within the next couple of days. But that was tough news to get right when I'm coming to talk to you guys. We have backup plans. Plan B is send it right to the Supreme Court. Plan C is a federal lawsuit. So we're not by any means giving it up. We're not giving up the fight. And thanks to people's generous contributions, we have, money to continue doing this. John, I think, has posted the writ pleadings on your website. So
no, it should be there. Yes.
If you want to read through them, you'd be very welcome to do so. I think my colleague Greg Anderson did an amazing job preparing the substantial parts of the pleadings, and we had a law student, Mike Zawalski, who did some research for us, which was nice because law student comes at a cheaper price. And we were all working at, less than what our ordinary hourly rates would be. And we were also, not charging for every hour that we spent, because Greg and I were back and forth with each other's offices, for days, fine tuning things and that kind of thing. So there's also something associated with that. We got interviewed by the St. Louis Business Journal, and I sent John a link to that article, and I think he's got that posted as well. And that article was interesting to me because the reporter, Jacob Kern, talked to the city spokesperson, Jacob Long, because I had said to the reporter when we were talking about it, of course, the writ involves the county execution stay, not the city. But I had talked to the reporter and said, we keep hearing there's all this money for landlords and tenants, but where is it? Why isn't this money being given out? So he asked the city spokesperson, Jacob Long, about this money. And this guy said that there was $7.5 million and $500,000 has been given out so far. And he also said in the article, and like I said, I think John's got a link posted to it, or got it posted so you can look at it. But he said that, sometimes the tenants don't show up for the meetings they have to attend to qualify for the money. And this is exactly what we've been trying to tell the judges is, there are a lot of tenants out there who are professional tenants or, professional deadbeats. They know how to play the system. And until the sheriff comes and posts their door and says, we're coming to put you out, they're not going to lift a finger. They're not going to pay the rent. They're not even going to try to get help. I mean, it's amazing to me that they won't try to get assistance, but why should they? That's work. Why should they go to the bother? So they're not doing it. So this is what we felt. We felt that some of it was probably tied up in bureaucracy, but we also felt that a lot of these tenants were just burrowing down and not reaching out, getting the COVID help and, that kind of thing. So that part is very frustrating. And I can assure you that when I talk to Judge Burleson in the city, which I hope to do in the next day or two, I will be pointing that out to him and saying, did you see this article? Did you see what they said? It's not that the money is flowing slowly because of bureaucracy, although that may be part of it, but it's also the tenants. They're not, hoisting themselves up to get this. So that's our bad news to lead. We are also sort of dealing with the various permutations of the CDC order. Now you understand that there's a declaration that the tenant has to give to you or give to us if we're representing you or your lawyers, stating certain things in order to qualify for the CDC stay. And it only applies to evictions for rent. It doesn't apply to unlawful detainers or 441s or commercial or post foreclosure or anything like that, just to rent evictions. And they have to say that they've been trying to make payments, and they have to say that they've applied for help. what we are hoping to do, and we're going to have our first one. Christine, is that set for next week or the week after that?
October the 8th.
October the 8th.
2 weeks.
When we get one that's been filed, a CDC declaration, we're noticing up a motion on it if we already have a lawsuit on file, so that we can put the tenant on the record and make them state what they've done to make partial payments, apply for assistance, that kind of thing. Because we think, frankly, some of them are, hard to believe, not truthful. I know. You're shocked. I can tell.
It's the big one. It's the big one.
Right. So we are figuring we're going to be developing kind of a form motion that we're going to file. Our judge in the county has been, fantastic about giving us dates for all these kind of things. And we will be, questioning those tenants and making sure that they know they just can't get away with it. Unfortunately, the publicity surrounding the CDC order would lead people to believe that evictions are just stopped, not that you have to do these additional steps. So some tenants may just be, possessed of the notion that they don't have to pay anymore until the end of the year. I think that's a bad strategy for anybody, but I think that, that might be the case. But we're intending to fight those. And I think we said this last week, but I'm going to say it again. I think our recommendation and our strategy is, if you have someone who's behind in rent, try to get the lawsuit on file before they give you the CDC declaration, because that way we have the ability to take it into court and cross-examine them under oath about whether or not the statements made in the declaration are correct. We had another big docket yesterday, Christine's county docket, with Chris and I both helping her. Christine, I thought it went fairly well. We only set 3 for trial. We have 1 CDC motion coming up. And we did have some tenants who talked about getting help from various agencies. I did talk to Better Family Life for one tenant yesterday. So, but what I think here is there's a correlation between the people who are going to show up for court, virtually, and the people who are also going to reach out and try to get some help. Those are the people who want to keep their place, they want to pay, they want to get help, and they want to try to do that. But we are seeing, I think, some more people who are trying to reach out and do that. Christine, is there anything you'd like to say about the county or the docket or anything?
Not really anything new. I'm curious to see what happens with this evidentiary hearing that we have set in 2 weeks for the CDC order. I'm not sure how the courts are going to handle it, or in particular, the judge that we're in front of is going to handle it. I'm not sure if it's going to be swayed in favor of the tenant, and if we can't prove anything otherwise, then the stay will be in place. So I'm curious to see how that goes. And it's certainly on a case-by-case basis, because every tenant and situation is going to be different. So we'll see what they have to say. I think a lot that we can also argue is, if during this evidentiary hearing, we can get them to, maybe admit, or we have something to show that they weren't truthful in their declaration, that may be something. But I've had a few of my landlords that have already gotten these declarations before they could even send it to me to file, which, again, we're better off filing so that we can challenge these things in court. So I think we're still waiting on an update to the challenge that out of Atlanta.
Yes.
I don't think there's been an update, right?
There is, they've added some more parties as plaintiffs to the pleadings. They have, the CDC has a deadline to, or the government has a deadline to respond by October 2nd. And then the plaintiffs have another week or 2 after that to respond. So that'll be a few weeks before we know anything on how that's going to go. I think one of the positives to the CDC thing is you might be able to use this to leverage your tenants into applying for the aid and getting you some money if you have people who aren't paying because of COVID. And I mean, if you are unlucky enough to get a CDC declaration before you've gotten your lawsuit on file, I would be inquiring of those tenants, well, where have you applied? You know, the approach I took yesterday when I was talking to people on the docket who were telling me they'd applied for help was, where have you applied? Can you send me the email? Can I give them documentation of what you owe or your lease or anything? You know, can we do anything to help you or, you know, speed this up? And a couple of people were interested in having that help. So,
certainly on any that we didn't get to file suit yet. If you're getting those, if
Yeah.
you feel free to inquire and ask them questions. You know, hopefully you can keep it on a good level and it doesn't turn volatile or anything. But certainly ask questions and say, you know, do you know about all these organizations? I can give you a list. I can, you know, I'll do what I need to do. Or provide what I needed to provide to the organizations if they need information from landlord to help facilitate and get this moving along to get the help that you need. So certainly talk to them, question them. You're okay to do that. And then the other important thing, I don't know if Kathie's previously mentioned it, is the CDC order say, it applies to everyone. It's not like the CARES Act where it only applies to certain landlords. It applies to everyone, and it stops that eviction anywhere in the process. So even so that's why it's important to, and we can challenge it anywhere in the process as long as we filed, so that we can go into court and challenge it. And we won't know until we've challenged a couple of these how successful we're going to be on challenging them. So
yeah, you know, we are really working every angle that we can to get, you know, to get the fairness and the law back for, you know, for both sides. One of the things that I think is interesting is I think some of the schools are starting to open up again and other areas are making progress. And I don't really understand why, you know, this one part of it, you know, everybody seems to be able to just, you know, whack the landlord over the head over and over again. And, you know, we're not getting any love. The other thing I guess I should say about the county is they did go to phase 1 last week. We didn't find that out until after we filed the writ, but amazingly enough, they did go to phase 1. And supposedly they have to stay at phase 1 for at least 2 weeks. And in the past, when they went to phase 1 for a week or so, they slid back to phase 0 immediately. But there is, you know, Judge Burton has tied the eviction stay to going to phase 2. So if we get to phase 2, presumably the sheriffs are going to start working through all those evictions again. And also, of course, you know, if you're in the position of having someone who's not paying, we think that some of the properties have probably been vacated. So call us or call your lawyer to talk about alternatives like notice of abandonment and that kind of thing if you think there's a good chance that the people have moved. We have gotten some possessions, you know, by going about it that way. It's another tool in the toolbox. Someone, I think Jeff, posted a question about where you can get a list of the organizations. If you go on the St. Louis County website, they have a tab that you can click to go to the COVID page, and they have a list of organizations. You can also call 211, which is the United Way helpline, and they can get you information about the organizations because the United Way coordinates with a lot of different organizations. The city also has COVID related links on its website that you can go to the city, you know, main website and click on that and get a list. And someone who works for the city told me recently that the Missouri Municipal League, which is a state organization, has some resources on its website for small businesses. And a landlord is essentially, you know, a small business. So I would encourage you guys to reach out and try to get help too. if you need it. If you're doing great, then great.
And it's stlcorona.com. That's the St. Louis County site.
Hmm.
STL Corona, CORONA.com.
Thanks, Christine.
Thank you.
Have we got any other questions? I guess the one other thing I'm going to say is in Jackson County, after the CDC order came out, they issued an order about what people were going to have to do, what landlords were going to have to do in Jackson County to go forward with evictions. They've done a similar order in Jefferson County. The city and St. Charles have not done that yet, but we could end up facing the situation where we're going to have to send this declaration to the tenants or send them notice of it or that kind of thing. I think that's completely unfair because why do we have to serve this on them? You know, they should be able to figure it out on their own. And frankly, I think if they've really applied for help, the organizations that they're applying with are going to tell them, here's the declaration, fill this out and send it to your landlord.
Mm-hmm.
So I'm opposed to that. It hasn't happened in the city or county yet, but I think it could.
Because I thought in the county on one of those talks that you're on, Kathy, I thought there was even discussion that they might start including that with the summons and petitions that get served to the tenants so that they get that. And
that was talked about a little bit. And
I don't know if they're going to go there or not.
Yeah. If the court wants to send it out, fine. I don't think we should have to send it out. I don't think the landlords or their attorneys should have to send this out. This is basically working for the other side. It should not be our responsibility to do that. The tenant lawyers, as you can imagine, who I've been friendly with most of these people for years, but I'm getting more and more annoyed with them. And they basically wanted the landlords to have to file sworn affidavits, notarized, saying that they hadn't gotten these affidavits. But the tenant's declaration, while it's made under penalty of perjury, does not have to be notarized. I got kind of testy when they started talking about that, I have to tell you. I don't think that's fair at all. You know, we're professionals, we're attorneys, we know what the law is, we know the CDC order is out there. We're going to check with our clients to say, have you gotten this as part of our preparation for a lawsuit? We're not going to just ignore it. It's insulting to me that they think that we have to do all this stuff when really the CDC put the burden on the tenant to come forward and make this declaration. Okay, I'm done yelling.
Great point. Very good point, though, Kathy. That's absolutely right. Yeah.
I have a question. Why is it important that we have the lawsuit filed before they give us the declaration?
Because if it's not filed, then you can't file it. And then we don't have any way to put them under oath and cross-examine them in court about whether the allegations in the declaration are true. You can still question them about the declaration, try to find out where they're getting help and that kind of thing. But technically, it would be a violation of the CDC order if you got the declaration and then filed suit.
Gotcha.
Christine, do you agree?
Absolutely. Absolutely. That's why we're pushing. If you haven't gotten it, then and you have reason to file, it might be in your best interest to proceed with filing. You might still get the declaration and have to stay, but at least then we've got the means, which is the court system, to then challenge the CDC order and request this evidentiary hearing and make them, appear under oath and testify to what they've done.
Yeah. Thanks for the question, Dwayne.
Mm-hmm.
Anybody else got anything?
I just think you gave us some great updates. I'm kind of disappointed. Like, I know not as much as you with the writ. Like I was telling you earlier, I finally got through and read all that, and that was a whole education for me in itself. And I can only imagine the amount of time and research that went into all that.
Well, I think I said this to you guys last week. This is my first writ. I mean, big learning curve there. It was fun to do in that respect. It's always fun to do something new, but it's a little crushing right now. I mean, I really got the news like 2 minutes before I logged on, to get denied. We know that most writs are not granted, but we thought this one was really good and that we had a chance. So
Mhm.
We'll go to the Supremes. We'll go to federal court. We'll keep pushing.
Yeah, I do encourage everybody to read that too, and the article from the interview that Kathie had. This is just, if you want to know anything about what's really going on, and this is as current as you could possibly get on any of this, I really recommend that you read that and spend the time to go through it. It's just, it's
I
well
appreciate
worth it.
that, John. I
Yes.
appreciate it a lot. I want to put out a shout to my colleague, Greg Anderson, who did the drafting.
Mhm.
You know, we were all working on it and helping, and probably helping more than maybe he would have liked some days, but he really did an excellent job with the research and the drafting. And we also had a law student, Mike Zawalski, who did some of the research. It was just very good work.
Mhm.
Okay, I'll give you a heads up, Kathy. Greg called a minute just ago, and he said, yeah, we got that writ. It's in. It's really good because we haven't got told no. And I said, yes, you have been. And he says, no, we haven't. I said, Kathy just announced it. And he goes, really?
Aw.
Oh, no.
So he may be looking for you.
Yeah. Maybe I should close my door.
I told him you were plugging for him and gave him good news or good words. So
Yeah.
he said,
Yeah.
well, that's okay. But it was pretty funny.
Yeah. He's a great lawyer.
Mhm.
Yeah, to the point and get her done.
Yeah.
Mhm.
So if nobody else has anything for us today, we'll see you next week. We'll be emailing stuff to John as it comes in to post on the website. So keep an eye on your website,
Thank you.
and we'll talk to you soon.
Thank you so much. We really appreciate that, Kathie, and you too, Christine. And tell Christopher hi. We missed him today, but we understand you guys have a lot more going on than just us.
It's a lot. It is a lot. Yeah.
Yeah.
Thank you.
Thank you.
Thanks.
Thank
Thank you.
you.
Right. Okay, if anybody wants to hang on here, we're going to have another haves and wants session.
Mhm.
And I hope that's why we got a few extra folks here. So I will say we've had if you have something, a have or a want, a property you want to sell or something you're looking for, you can put your contact information in the chat. But then also we ask you'll go ahead and you give us your email address or your telephone number, how you like to be contacted, so that people watching this on the replay from our website can also pick it up, because they can't view the chat if they're just listening on the replay. So who's going to get us started today? I'm sure somebody's out there itching to do a deal.
Mhm.